Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 198. This is the counterpart to the one I did with Miriam on 197, which was about looking back over 2020. With a stunning predictability, 198 is going to be about looking at key cases that are coming up in 2021 for decision. Some of them we've talked about before in the podcast over the years. Some of them we haven't. Some of them are new. So I thought it would be great if Chris Fisher, my fellow partner in the employment team, and I took a look through these. He's going to make predictions. Chris has the annoying habit of being entirely right in his predictions. So I'm certainly hoping that this year he's going to make a complete horlicks of it and get every one of them wrong, which will do my ego no end of good. But more importantly, the other reason for asking Chris to join is that, in fact, Chris will be taking over the podcast series from January 2021 because I am moving on from Mayor Brown, seeking new challenges. Now, to enliven this podcast, one of the things that Chris and I have agreed is that I will, on at least 2 or 3 occasions, attempt to smuggle in the name of the law firm that I am joining after Mayor Brown. And Mr. Fisher has been armed with a buzzer or a bell, which he will buzz or bell when I try and say the name of the firm that I'm going to. So we'll see how I get on and whether I'm able to smuggle in the name of the firm that I'm going to. So, Chris, do you want to talk about your first case then?
Sure. Thank you, Nick. Hello, everyone. Yes, there are a number of important and interesting cases I think that should come out next year, and it's been difficult to pick the 3 that I have, but I've done that. I've gone for 3 Supreme Court cases because I tend to think that whenever there's an employment case that makes it all the way to the Supreme Court, it's worthy of attention. And just to say before I start that I'm very grateful to Nick for handing over the podcast to me. I will do my best to treasure it, and I hope I live up to his high standards as we go forward next year. And I do have my buzzer bell ready to avoid any unfortunate breach of firm protocol. Anyway, first case is the Flowers case. It's a holiday pay case. And it's going to be heard by the Supreme Court next June. And the full name is Flowers versus the East of England Ambulance Service. So this looks at the issue of what elements of remuneration go into holiday pay. And as we know, because of European case law, it's not as simple as simply calculating holiday pay based on basic salary in some cases. European law requires workers to be paid their normal remuneration during their holiday. And that includes anything that's intrinsically linked to their job. So this has created a stream of cases over recent years, as you're probably aware. And one issue that those cases have looked at is the extent to which overtime has to feature in an employee's normal remuneration. Now, until Flowers, the cases had mainly looked at what's known as non-guaranteed overtime. So that's overtime that an employee has to perform if the employer requests it, although the employer isn't under any obligation to offer it. And in those cases, typically the courts have said that non-guaranteed overtime should be included as normal remuneration for holiday pay purposes. So this left the question, though, what about purely voluntary overtime? where there was no obligation for the employee to do it, no obligation for the employer to offer it. Did that have to be included or not? So then we come to the Flowers case. Now, the Flowers case concerned a group of NHS employees in the ambulance service who worked both types of overtime. They did non-guaranteed overtime that could come up at the end of a shift. If they hadn't finished a certain task, they could be required to continue working by way of overtime to finish it. But they also were eligible for voluntary overtime if they volunteered to work extra shifts, but there was no requirement for them to volunteer for that. So the tribunal at first instance looked at both of these and it said, well, non-guaranteed overtime based on the case law should be included in normal remuneration, but they didn't think voluntary overtime should be included, and that was on the basis that there was no contractual requirement for the workers to perform any voluntary overtime. Now, on appeal to the Employment Appeal Tribunal, that got reversed on the voluntary overtime point, and the EAT said that it doesn't matter whether overtime is required by the contract. All that matters is whether there's a pattern of overtime that's sufficiently regular for it to amount to normal remuneration. And that went on to the Court of Appeal in the middle of last year, and they agreed with the EAT. So they said, again, the test is whether there's a pattern of overtime that's sufficiently regular and settled for the payments to amount to normal remuneration. But there is no separate requirement for overtime to be required under the contract. So an important decision clarifying, well, semi-clarifying the position on voluntary overtime. We'll see what the Supreme Court makes of it. My prediction,
Go on,
trying to keep my yes. I know. I don't think I really am sticking my neck out on this, but I think they'll uphold the view of the Court of Appeal and the EAT. I think it makes sense that the decision in the EAT and the Court of Appeal, the basis on which that's been decided. I think the practical issue, I think, for our clients and for employers is, well, when does voluntary overtime become sufficiently regular to be normal remuneration? Of course, that's going to be a very fact-specific case, but it may be we start to see cases more along that line being decided by first instance tribunals. So far, I think the cases have been at one end or the other of the spectrum, and it's been fairly easy to take a view, but there's obviously a very large grey area in between. But yeah, so that's my first case, the Flowers case. I think that's an important one.
I think it is an important one. I certainly agree, because if there's a distinction between any overtime and it's a distinction between contractual overtime for holiday pay and any overtime, that has a wage bill consequence. It has an operational consequence. I don't know how open and shut it is. I mean, I'm not necessarily disagreeing with you about the likely outcome. I could see a court going, we're going to take a pragmatic view here and go, if there's a contractual obligation, that puts it into play, and if there isn't, there isn't. So it'll be interesting to see.
I think there was I think they were following on from the British Airways case where they locked onto the requirement in the contract point, but the EAT and the Court of Appeal seemed to steer away from that. So yeah, it'll be interesting to see if the Supreme Court goes the other way.
Yeah. Okay, well, let me pick up on a case, a Supreme Court case as well, in fact. It was the first of my choices, which is Coastal Dunkley. Now, and I've been through this in the podcast previously, but so I will try and summarise. But it's off to the Supreme Court, and it's to do with collective bargaining and its circumstances in which an employer can write directly to employees who've got a recognised union. Now, legal background, Section 145B of the Trade Union Labour and Relations Consolidation Act, TOCRA, prohibits employers from offering incentives to employees to bargain directly with the employer rather than collectively. Section 145B itself states that it is prohibited for an employer to make an offer directly to an individual who is a member of an independent trade union, which is either recognised or seeking to be recognised by the employer, and the employer makes the acceptance of the offer conditional on the employee agreeing that the individual's terms of employment, or any of those terms, will not or will no longer be determined by collective agreement negotiated by or on behalf of the union. The employer has to have the sole or main purpose of achieving that result in the offer that is being made in order to be caught by the legislation. So key parts, you've got a recognised trade union or a trade union seeking recognition. There's an offer directly to the employees, and the sole or main purpose of the offer is that the employees' terms will not or will no longer be determined by collective agreement. So here, Coastal had a recognised trade union, no dispute about that. There was a pay round. In return for a particular pay offer, Coastal wanted employees to agree they were going to give up certain rights in their contract, but that was nothing to do with whether or not the union was going to be recognised. The pay offer was rejected in a consultative ballot that the union put out, and then there was deadlock. On two separate occasions, Coastal wrote directly to the employees inviting individuals to accept their relevant offer. Eventually matters were resolved, but the employees then brought a claim saying there's been a breach of section 145B. And they said that the effect of accepting the employer's offer would be that the terms in that offer would no longer be determined by collective bargaining, which was of course a stalemate. It would have instead have been determined by one-to-one bargaining. To the extent that the offer was an improvement on the previous terms, then they said that the offer was in effect an inducement to agree that this particular offer would not be negotiated collectively. And Coastal, in contrast, said they were perfectly happy to carry on recognising the union for all purposes. They were simply attempting to break the deadlock. The Employment Tribunal and the EAT agreed with the trade union, and so Coastal were looking at a fairly significant compensation payment. So they go to the Court of Appeal. The Court of Appeal took a rather different approach from the Employment Tribunal and the EAT, and they said that the legislation was designed to prevent two situations. In the first, the employer offers an incentive to employees to prevent a trade union becoming recognised. Alternatively, the offer might be made by an employer to obtain the withdrawal of the recognition of a trade union's right to negotiate on a collective basis. Both of these results would be prohibited. Instead, the court said there was no basis for saying that the legislation was intended to apply to a third situation, which was the one that had arisen here. There was deadlock in collective negotiations, and the employer writes directly to the employees, inviting them individually to accept a particular offer. The Court of Appeal's reasoning was pretty convincing, I think. First, they said if the trade union's interpretation of the legislation was correct, it would give a veto to the trade union in practical terms. If the employer was not allowed to go directly to the employees on a particular offer, then the union can always veto this. But on the other hand, if the company's interpretation was correct, it could make an offer directly to the workforce, but this did not emasculate the trade union. If the employer went directly to the workforce on a particular occasion, trade union can still ballot for industrial action if it and the workforce felt sufficiently strongly. The alternative would either be unworkable or it would simply produce stalemate. So we're off to the Supreme Court. My view is that I think the Court of Appeal is undoubtedly right. I'm aware that is not a popular viewpoint, so it'll be very interesting to see what the Supreme Court do, but I'm going to stick my neck out and say that they will win, that the employer will effectively hold on to the Court of Appeal decision. But in any event, I do wonder if there is a way round this, even if the employer loses the case in the Supreme Court, because I don't think reading the earlier judgments there's anything to stop an employer expressly saying to employees, I'm going to carry on negotiating, but here's an offer that I wish you to accept, subject to that ongoing negotiation. Clearly, that then means that there's no conclusion of the pay round negotiations. The employer may be less flexible in the subsequent negotiations, but I think it'd be quite difficult for a trade union to say the offer was intended to end collective consultation, even in relation to those particular terms. Anyway, we'll see. First of all, we'll see what the Supreme Court does, and then we'll see after that whether the workaround that I'm suggesting becomes something that people adopt to try and sidestep that hypothetical at the moment finding. So there we go. That's Coastal UK Limited and Dunkley.
Good. Thanks. I think it's an interesting one. That one. Have you seen clients making offers more as a result of Coastal in your experience? Or is it still fairly?
I think the Court of Appeal reassured everyone, and so people. We certainly had one case where I had to give advice where an offer was being made. There was a recognised union. It was being made to cut through the chatter, if you like, and we looked at Coastal, but came to the way Court of Appeal, we think it's clearly right. But even allowing for the Supreme Court, it was one of those where, well, there's a risk either way. Well, there was no zero risk option. Either you hold up the pay negotiations with all the problems that go with that, or you cut through it, make an offer, and then see what happens. So they would be tight and barred now. It was early on in the year, so I think we would be relatively comfortable, but Still, I shouldn't say any more about the specifics of that one.
Yes, indeed. Okay, right. My turn again. My next case is again a very well-known one. It's the equal pay case, ASDA and Brearley. Again, another Supreme Court one. This has actually been heard by the Supreme Court earlier this year, and we're waiting for the judgment to be handed down. So I think, as Nick has talked about on the podcast, typically in years gone past, equal pay claims have been the preserve of the public sector, but ASDA and certain other supermarket claims that have come out recently, I think, have reminded us all that equal pay law applies as much to the private sector as to the public. And certainly since the introduction of gender pay gap reporting, it's an area where there's been a much greater focus, and one where employees are more aware of their rights in the private sector than perhaps they were before. So the ASDA case, just as a quick reminder, it's probably the best known of the supermarket claims, and it's a whopper. It's about 7,000 ASDA employees, mostly female staff, bringing the claim, who work in the retail stores at ASDA across the UK, and they're looking to compare themselves with the predominantly male employees who work in ASDA's distribution depots, and who, it's claimed, receive higher pay. So the claim is that the female retail employees do work that is equal value to the male distribution employees. So not that they're rated as equivalent or that they're doing like work, but that they do work of equal value. So now the issue, that's the equal pay claim that's being brought, but the issue that's currently being considered by the courts in the ASDA case is only a preliminary point to decide whether the employees are entitled to compare themselves to the distribution workers under the relevant law. Now, the reason this is an issue is because they work at different sites, and because of that, the UK law, the domestic law at least, requires that they be employed on common terms. Now, at first glance, it doesn't seem that they are, because the retail workers are employed on ASDA's retail terms and conditions, which are not subject to any collective bargaining, because the retail staff are not, by and large, unionised. The distribution workers, on the other hand, have their terms collectively bargained through the GMB union. So ASDA's position is that, well, these can't be common terms. They're very, very different, and they're bargained very differently. So the claim should not be able to proceed. It should be struck out as a preliminary issue. Now, the courts so far have disagreed with that view, including the Court of Appeal last year. They've clarified that the test for common terms is not whether there are common terms as between the retail workers and the distribution workers as such. The question is whether the terms for the retail workers are common across the relevant sites, and likewise for the distribution workers, i.e., would a distribution worker be on broadly similar terms regardless of which ASDA site they work at, and would a retail worker be on broadly similar terms regardless of which site they work at? And the fact that in the ASDA case, the retail workers would never work in a distribution centre, and the distribution workers would never work in a retail store, didn't matter. The question could be asked on a hypothetical basis. So the court so far have said the claim can proceed and the comparison can be made. My prediction for this case, again, probably not sticking my neck out particularly, I'm going to say the Supreme Court will uphold the Court of Appeal's reasoning for under the domestic law. I can't see them going in any other direction. I think it's a logical conclusion that they've come to. I think they pointed to the drafting in the UK law not being particularly attractive, and there were some grey areas to it. But I think if the retail store workers would be on the same retail store terms, were they to be working out of a distribution depot, then it seems right they should be able to bring an equal pay claim based on male comparators at that distribution depot. The fact that that's a hypothetical situation between these two classes of employees shouldn't make a difference, I don't think. And that's, I think, the logic behind the decision, because otherwise employers could segregate different types of male and female employees as a means of avoiding equal pay comparisons.
I'd agree with you, Chris. I think I think the chances of the Supreme Court taking a radically different view pretty limited. I think the challenge is that a lot of the procedural issues need to be sorted out. So I think it's entirely understandable Asda is taking these points, but they're all a sideshow to the main issue, which is is it work of equal value that's being paid unequally, and if it is there a genuine material factor there? So,
exactly. Yeah, I mean, given it's taken over 5 years, I think, to get to this point, one wonders how long the actual substantive case will take.
Yes, you feel that the claimant's missed a trick by not choosing a Ms. Jarndyce to be their lead claimant or something to make the point that maybe the tribunal could actually deliver a result quicker than Jarndyce. But we'll see. Okie dokie. So I on the podcast yesterday, I took a lesson from Miriam, because Miriam asked to choose a case for looking back at 2020. In fact, chose 3 cases for one of her cases. So I'm going to choose 2 cases for one of my cases. And it's an area which I think is one of the fault lines in society. And I've talked about this in the past a bit, but the distinction between private lives and the work sphere, and what employers can do relative to employees in respect of things in their private life. Here we're talking about philosophical beliefs, in 2 cases involving philosophical beliefs that are going to go up to the EAT. But I think it's going to be an absolutely crucial issue for employers. So the first up is the Forstatter case, where she was employed by the Centre for Global Development, and actually then she went on to a consultancy arrangement in January 2015. Her case, and the facts of this have not yet been tested, is that the consultancy relationship was ended because she refused to continue it, because the respondent refused to continue it because of her expressions in connection with her views on a particular topic. The claimant contends that she was subjected to direct discrimination because of her philosophical beliefs, or has suffered indirect sex discrimination, as her view is more likely to be held by women than men. And in brief, that view, as I'm sure most people listening will know, is that sex is immutable, whatever a person's stated gender identity or gender expression is at any given time. The tribunal claim was started in March 2019. July 2019, a preliminary hearing was set up as to whether or not the claimant's belief amounted to a philosophical belief. The claim, I should say, was also put forward as a lack of belief on the part of the claimant, and the argument was that what she did not believe in was, some people believe that everyone has an inner gender which may be the same as or different to their sex at birth, and that gender effectively trumps sex, so that trans women are men and trans men are women. Typically, such proponents believe that trans women are women from the moment they identify as a woman, if not before. That was her belief. So there are extensive extracts in the tribunal judgment indicating the difficulties faced by discrimination against women and discrimination against transgender people. There's some truly depressing statistics on the prejudice suffered by both of them. So it's clear that there are real challenges here which need to be addressed. Now, obviously, the starting point for this case, Section 13 of the Equality Act 2010 prohibits direct discrimination if a person A discriminates against another B because of a protected characteristic. A treats B less favourably than A treats or would treat others. The definition of protected characteristics includes religion or belief, and Section 10 says the definition of religion or belief is religion means any religion. When a reference to religion includes a reference to a lack of religion, belief means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. So Article 9 of the European Convention on Human Rights is also relevant. General right to freedom of thought, conscience and religion, and to manifest that religion or belief, subject only to such limitations as are prescribed by law and are necessary in a democratic society. Article 10 gives the right to freedom of expression, which again is subject to such limitations as are prescribed by law and necessary in a democratic society for and including for the protection and the reputational rights of others. The Granger case, of course, sets out what the test is for what amounts to a philosophical belief. It's a belief which must be genuinely held, must be a belief and not an opinion or viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a level of cogency, seriousness, cohesion, importance, and this is the kicker, it must be worthy of respect in a democratic society and not be incompatible with human dignity and not conflict with the fundamental rights of others. Tribunals have been advised not to set the Granger threshold too high. For example, whether a belief is genuinely held, it should be a question of whether the belief is held in good faith. In deciding whether or not a belief attains a necessary level of cogency, that threshold should not be set too high. Now, one of the interesting points in this case was around the lack of belief and how that is defined. Both parties apparently approached the case on the basis that the Granger case, the criteria applied equally to attest whether someone had a belief or had a lack of belief in something. Remember, the claimant here had framed her case, Ms. Forstater had framed her case as a positive belief in sex being immutable and a lack of belief that people could self-identify. The judge, although had some hesitations, came down generally in favour of deciding the Granger criteria should be applied to a lack of belief claim. I'm not entirely sure I agree with all deference to the judge on that, because if the test for lack of belief is the same as the test for belief, your lack of belief has to have the same level of cogency and seriousness of thought as the belief test, which means that the lack of belief protection would be applicable only to zealots and true non-believers. People who think an issue is unimportant and don't live their life on that basis would then seem to fall through the cracks and have no protection if their lack of belief was counted against them. Anyway, the tribunal went through the analysis through the Granger test and decided that the claimant's belief was that sex is biologically mutable, and the claimant did not accept that in any circumstances a trans woman is in reality a woman or a trans man is a man. The tribunal accepted that the claimant's belief went to substantial aspects of human life and behaviour, had a level of cogency and coherence, but the tribunal said that the claimant's view is incompatible with human dignity and the fundamental rights of others. If a person has transitioned from male to female and has a gender recognition certificate, that person is legally a woman. That is not something the claimant is entitled to ignore. Well, to ward off the obvious criticism, the tribunal said that there was nothing to stop the claimant campaigning to have the Gender Recognition Act repealed or amended. She was entitled to put forward her view that there should be some spaces that are limited to women assigned female at birth, and where that is a proportionate means of achieving a legitimate aim. It does not mean her views are protected for the purpose of the Equality Act, however. So, in short, the claimant could legitimately put forward arguments about the importance of some safe spaces without insisting on calling trans women men. People cannot, according to the tribunal, expect to be protected if their core belief involves violating others' dignity and or creating an intimidating, hostile, degrading, humiliating or offensive environment for them. The tribunal did note that as a matter of courtesy, the claimant said she would use the preferred pronouns that a trans woman or trans men wish to have applied to them, but reserved the right to say that trans women or men, and that trans women are men, and that woman means adult human female. So overall, the tribunal in that case said her belief was not worthy of respect, and therefore her claim would fail because she wouldn't be able to show the necessary detriment on the grounds of philosophical belief. Well, the Higgs case, very similar. She was employed at a school, and the school received an email which indicated she'd made a posting on Facebook, which indicated homophobic and prejudicial views against the LGBT community, according to the complaint that came in. She was dismissed. Mrs. Higgs brought claims on the basis, too, that she'd been discriminated against on the grounds of religion, and claimed that she'd been unlawfully harassed, contrary to Section 26 of the Equality Act. The school disputed some of the beliefs that Mrs. Higgs sought to rely on as being the basis for her religious discrimination claim, and she contended that she had a lack of belief in gender fluidity and a lack of belief that someone could change their biological sex/gender. So the first thing the tribunal had to do was consider whether those two beliefs were protected beliefs. And the school accepted that these two beliefs met all of the Granger criteria, apart from the one about being not incompatible with human dignity and worthy of respect in a democratic society. The Employment Tribunal in the Higgs case had some careful, but I think pretty cogent comments to make in connection with Mrs. Higgs' beliefs and whether they were worthy of respect. The tribunal acknowledged the earlier cases, and the Forstater case in particular, that the claimant in those two cases would not recognise someone who viewed themselves as gender fluid, and therefore, in the earlier cases, the Forstater case, the claimant might misgender people. Well, the tribunal in the Higgs case accepted that if the only way in which you could manifest a particular belief would be by acting unlawfully, then that might lead you to accept that belief was not worthy of respect in a democratic society. But if someone was choosing to manifest a belief by acting unlawfully, that doesn't necessarily lead to the same conclusion. The tribunal said they could see no reason why the belief from Mrs. Higgs would lead to unlawful action by her. They then reached the nub of the tribunal decision on this point. Quote, the belief that sex and gender are set at birth may be upsetting to certain people, but if freedom of speech and the rights within Articles 9 and 10 of the Convention only extend to expressions of belief that could upset no one, they would be worthless. Equally, to find as the tribunals did in the cases to which we were referred, brackets, that's the Forstater and a case called Macareath, would amount to a declaration that it is open season on people that hold and express the beliefs in question. They do not deserve protection. That seemed to us to be a strange and somewhat disturbing conclusion. And so the tribunal went on to have a balancing act between those who held the beliefs in question and those who opposed them to decide whether or not the beliefs were worthy of respect in a democratic society. And it came down very succinctly deciding that Mrs. Higgs' claims did pass the final test, and therefore her beliefs in relation to gender fluidity were covered by under the protection of the Equality Act. They then went on to decide that she had not, in fact, been discriminated against on those grounds. But the point for the purpose of the podcast was they accepted that these unpopular views were worthy of protection. Now, both cases are going up to the EAT, we understand. I saw a posting from Ms. Forstater saying that her hearing is due in April 2021. I don't know when the Higgs case is going to be heard. But I think these are fantastically important cases. My personal view is that the Higgs case adopts the correct approach, and that in the Forstater case, the judge may have slipped into the error of confusing the manifestation of a belief, whether or not she would misgender people or feel able to misgender people, with whether that was necessarily necessary for the manifestation of her beliefs, which I don't think is the case. So it'll be really interesting to see, but there's no doubt these cases will stir up huge controversy. And I think I'd be very surprised if they ended at the EAT. So I think it's going to be fascinating to see what happens and which side of the debate the EAT comes down on. Chris, what do you think?
Yeah, absolutely. Absolutely. I mean, I think it's hugely interesting. I always think, the belief cases are the hardest for an employer to grapple with, because what type of policy do you then adopt depending on which way these cases turn out. So it's incredibly difficult to manage an employee, and then and you see in the Higgs case where they then decide that actually she wasn't discriminated against because what she was doing was going beyond the beliefs that she held, or when is that line crossed. So I think I think they're fantastically interesting cases, but so difficult for an employer to really apply them in practice.
They have a colossal impact on day-to-day employment issues, because you're trying to manage someone. No matter whether you can't touch me because this is my belief, or that's my belief. We had the case, remember the knowledge meeting, about the Stoic. And the Stoic, amongst other things, reserved the right to say what they thought, irrespective of how it made other people feel. And the tribunal said, okay, we'll accept that's a sufficient belief. But, I'm refusing to say sorry. I am a Stoic. Therefore, you can't punish me for not saying sorry. Okay. Yes. And I'm sure there'll be some weird and wonderful beliefs coming up.
Absolutely. Very, very interesting. Well, I'm going to talk about my next case now, which is what you might say is not quite as is interesting, but I think it's pretty interesting. It's the little known case of Uber, which I couldn't leave out of the list. It was almost we thought it was going to be a 2020 case, and I don't think it can be now. But the Supreme Court judgment in this case is expected any day. It's obviously
appropriate for Uber. It's expected any moment. It's just taking longer to get there.
Exactly. They've just turned into your road, I think. So the this is obviously the Uber, the worker status claim, Uber and Aslam, and I'll run through it very quickly, but everyone knows probably the facts of this case. It deals with the case of whether Uber drivers, or these particular Uber drivers, are self-employed for employment law purposes, or whether they are workers, i.e. the halfway house category that we have in UK law between an employee who works under a contract of service and a self-employed person, someone who's in business on their own account. And the reason it matters in Uber, at least, is that if they're classed as workers, they'll be entitled to national minimum wage and paid annual leave for the time that they are working, which was the other important point that the court has had to decide. So far, Uber has been unsuccessful at each stage in the court system, and including up to most recently in the Court of Appeal. And as I say, the case came before the Supreme Court in the summer of this year, and we're expecting the decision anytime now. So much of the focus in the case has been on the complex contractual documentation that Uber has in place, which essentially provides that Uber doesn't provide taxi services for passengers. The contract for the provision of those services is between the drivers and the passengers. Uber is only acting as an agent for the drivers, and it's only providing them with a technology platform, which is the Uber app, which allows the booking and the payment to take place. So Uber's case is essentially actually that they are the customers of the drivers. So therefore, they can't be workers for UK employment law purposes. So at the very first instance stage, the Employment Tribunal said that it just didn't accept this premise. It didn't accept that the Uber documentation reflected the reality of the relationship between the drivers and Uber, and they relied on the case of Autocleanse and Belcher, which is another Supreme Court case from 2011, which allows courts to disregard the label that the parties have stated in contractual documentation where the court believes that it doesn't reflect the true agreement between them. And so that's what the Employment Tribunal did. It disregarded the self-employed label and it imposed a worker label of its own. And that finding survived all the way up to the Court of Appeal. And importantly, as I said, the other issue that's gone with that is a decision that the Uber drivers are working for the period of time, not just when they are driving passengers around town, but for the whole time that they have the app turned on and they're available for bookings. So that means that the time they spend driving around waiting for bookings counts for working time purposes for minimum wage and holiday pay. So that's hugely significant as well. Now, the one chink of light, I think, that came out of the Court of Appeal judgment was a dissenting judgment. It wasn't a unanimous decision in the Court of Appeal. One of the judges, Lord Justice Underhill, disagreed with the majority. His view was that Uber's contractual documentation wasn't a sham under the Autocleanse principle. He said there was nothing unrealistic or artificial about Uber's arrangements, and there was no real difference between the Uber model and most other minicab businesses. Now, he accepted, I think for political purposes, that there was an undoubted inequality of bargaining power between Uber and the drivers, because the drivers were pretty much required to sign up to Uber's standard terms and conditions. But he said that shouldn't be a ground for the courts to interfere with a genuine contractual arrangement. He said that was the job for legislation, not the courts. So, prediction for this case, I think a lot of people said Lord Justice Underhill's argument, I think, is a compelling one. I think it will be really interesting to see where the Supreme Court go on one of its earlier decisions, AutoCleanse. A lot of people are saying the Court of Appeal have widened that, the argument of what is a sham and what isn't a sham, and they're going to get a chance, obviously, to revisit that and perhaps reset it. I think it will stick with the decision that the drivers are workers. I think the fundamental difficulty for Uber in this case is the initial finding of fact that the tribunal made, that these contractual arrangements do not reflect the reality of the arrangements. And I think once that finding had been made, it seems Uber has been fighting a somewhat losing battle to try and overturn that, despite Lord Justice Underhill seemingly being willing to do that. I don't know what you think, Nick. What's your prediction for Uber?
I think you're right. I also think Lord Justice Underhill is right. I think it made perfect. I thought his judgment made perfect sense, and that in fairness to Uber, it has looked at what's gone before. It has structured its arrangements in a way which brings it within that, as it's entitled to do. And there's no law that says you can't set yourself up as a platform and operate in the way that they have done. I don't think it necessarily follows that therefore they have workers working for them. But I agree with you. I think the finding of facts can be kind of hard to get past. And there's no doubt there's a trend in favour of extending protection to people. So I think it would be a surprise. It would be a significant victory for Uber if at the 11th hour they managed to pull this one out of the bag. But it'll be heavily argued, that's for sure. So, yeah, it'll be very interesting. And I agree with you also about the AutoCleanse case, which I think is a bit of a menace, because I think it allows judges to go, I don't like the deal that has been struck, but I'm going to do it on the basis that it doesn't refer to the true underlying deal or something like that. So yeah. It doesn't. I mean, fortunately, it doesn't come up very often, but when it does, I think it just allows courts to ride roughshod over written agreements.
Yeah. Absolutely. Rather unkind references to batteries of lawyers drafting these agreements, which I always think.
I always draft my legal agreements with a battery. Trust me. Okay, so the final case is going to be relatively short because I don't know much about it, if I'm honest. But it's the case of Steer and Stormshore, which I saw referenced in an alert put out by Cloisters Chambers, and it's being done by someone who was a guest on the podcast earlier this year, Chris Milsom, and it's being argued in the AT as we record this, in fact. It's the suggestion that discrimination cases, claims for unlawful discrimination, should have with them the right to apply for interim relief in the same way that trade union discrimination claims for example, are able to apply for interim relief. Now, for those of you who have not had the joys of dealing with interim relief applications, broadly speaking, application needs to be made within 7 days of the dismissal taking effect. The tribunal has to, by law, list a hearing within a very short period after that. If the claimant is likely to show a high probability that they'll win at the end of the day, then the tribunal can restore them back onto the payroll until such time as the tribunal hearing, the final hearing, is determined. And if the tribunal decides at the end of the day that the claimant loses, the employer does not get its salary back that it's paid to the individual in the meantime. Now, we've seen this come up. Trade union cases, they come up from time to time, but it's not been generally more widely available. You can't get it in an ordinary unfair dismissal claim, for example. But there's no doubt that if employees were able to get their jobs back pending a tribunal decision, that would be massive. So I think it's going to be absolutely fascinating to see how it goes. Now, I don't know any more about it. I think I couldn't find the underlying employment tribunal decision on the website yet. I suspect this is an interim relief application, so I suspect this is rattling its way through the courts at top speed. So I think it's going to be fascinating. Their argument is that the disparity of protection is in breach of EU law, and that when you look at protection given, for example, to effectively trade union discrimination claims, then EU law requires, pursuant to the principles of equivalence, equal treatment, principle of effectiveness, that this highly effective remedy is given to victims of discrimination too. So I don't know when a decision will come out, and it will be absolutely fascinating to see where they go with this, and then whether it goes further. But presumably if it's an interim relief application whistling its way through the courts, it might end up, if it goes all the way to the Supreme Court, fairly quickly. Who knows? We'll see. I don't know the arguments. I cannot possibly begin to stick my neck out on this and whether it's going to work or not. I can tell you if it did work, it would be colossal. But that's the easiest of easy predictions.
That's fascinating, isn't it? It's a bit like the whistleblowing interim relief that's available under.
Yes, it's exactly the same. Yeah,
fascinating.
Yeah. It doesn't, in my practice experience, doesn't have to come up very much in whistleblowing. It's trade union discrimination. No. Trade unions are all over this, but often I think the whistleblowers aren't.
No, I don't know if that's because the relatively high bar of prospects of success, the cost, you have to act very, very quickly. But I don't. Yeah, I think you're right. I can see though it might.
If the whistleblowers haven't taken legal advice, by the time they take legal advice, they've missed the time scale for making the application.
Yeah. But you kind of think with discrimination, given there's so many varied times at which you can claim a complaint of discrimination, you could see that being much more widely used. Interesting that in times of Brexit, where there's talk of caps being imposed and discrimination law being pegged back, this would be a massive extension.
You add to that the number of redundancies that are going to come in the next 12 months, where people, and some of the percentage of those people say were discriminatory. Secondly, the delays in getting to a tribunal hearing. Employers would go from being sublimely unconcerned that it may take 18 months for a tribunal hearing to come on to being unbelievably concerned that it would take 18 months for a tribunal hearing to come on.
Yeah,
absolutely. It would be sort of high stakes stuff. So it'd be absolutely fascinating. Anyway, look, Chris, thanks very much for participating in that. I hope that was useful to people listening. I'm sure 2021 is going to bring a crop of another more interesting cases that we aren't even aware of as yet. So I think it's going to be an interesting year for employment law. This is podcast number 198. I'm hoping to get to 200 before the end of the year. And so the next couple of podcasts are just going to be, when I did my 100th podcast, I did things I'd learned about from being a podcaster. The 200th will be things I've learned about in employment law over the last 30-something years of practicing employment law. So that'll be good for a few anecdotes and a few platitudes, I'm sure. But the aim would be to send them out before I finally leave for... oh well, I almost got nearly. Okay, fine. But in all seriousness, I hope everyone will keep listening to this podcast under new management. And Chris, have fun taking it forward. And yes, I will be listening from in the hope that I am able to write in with interesting questions and observations. I think you'll find.
Please be delighted, Nick.
Yes.
You'll be the first guest on the podcast.
Yes, complete with buzzer. All right. Well, listen, take care, everyone. And until the next podcast, stay safe and out of harm's way. And Chris, thanks very much. And have fun with the podcast series going forward.
Thanks, Nick. Bye, everyone.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.